9:30, we'll call a special call meeting of the Fiscal Court to order. The purpose of the meeting this morning is to accept the report of Mr. Wicker. Do I hear a motion? Motion. I have a motion. Is there a second?
Second.
Motion and a second. All in favor of the motion say aye. Aye. Any opposed, no. Mr. Edwards, would you read the report?
Is that motion, well, I need to the motion clarified in that, is that a motion by the fiscal court, voted by the fiscal court to release this report, as it is attorney-client right now?
I'd make a motion to release the report.
Second.
That's what it takes.
Motion and a second to release the report. Maybe I didn't say that right. Okay. All in favor of that motion, say aye.
Aye.
Any opposed, no. Motion carries. All right, Mr. Attorney.
All right. The scope of this assignment, I am reading directly from the official report. The scope of this assignment was not clearly defined in the fiscal court's motion. We questioned each member of the fiscal court on the members' understanding of the assignment, and a consensus emerged. Therefore, we investigated the following two issues: whether County Judge Executive Mike Miller committed acts of misconduct related to the issuance of unemployment benefits to former Animal Control Officer Goldenrod Kirk, and whether County Judge Executive Michael Miller committed acts of misconduct in providing information about an executive session of the fiscal court to members of the media. It was not our intent to decide whether Judge Miller violated the ethics code. Marshall County has an ethics code vested with that authority. Moreover, Judge Miller has a number of due process rights in an ethics commission hearing, including right to be formally presented with charges against him and the right to present a defense. After such a proceeding, the ethics commission might reach a different conclusion. It was also not our intent to decide whether Judge Miller is guilty of violations of criminal law. A criminal defendant has the right, among other things, to be charged by a grand jury, to have notice of the charges against him, to call witnesses in his own defense, and to have his fate determined by an impartial jury. Those rights would not be afforded in an investigation such as this one. We limited the scope of our investigation to the two acts of misconduct set out above. We learned of a number of other allegations during the course of our work, including charges of corruption related to the Refuse Board and acts of retaliation against members of the fiscal court. Fiscal court may request additional investigation from us if it wishes to do so, but we did not understand our commission to include those issues. Finally, we found that most of the witnesses we interviewed have strong feelings about the job performance of the county judge executive and the commissioners. It is clear that the members of the fiscal court have a strained relationship. Governing bodies often work best, however, when the members of the body hold each other accountable for their actions. It is the responsibility of the commissioners to question the acts of the county judge executive and his staff, and to bring those issues before the voters. Ultimately, it is the responsibility of the voters of Marshall County to decide whether an elected officer is doing his or her job properly. Methodology. We conducted interviews of the following persons: County Judge Executive Michael Miller, Deputy County Judge Executive and Fiscal Court Clerk Melanie Chambers, County Treasurer Emily Martin, Commissioner Bob Gold, Commissioner Misty Drew, Commissioner Terry Anderson. We attempted to interview Mr. Kirk, but he declined to do so through his attorney, Gary Haverstock. We also reviewed the following documents: fiscal court minutes for the period January 3rd, 2013 to July 2nd, 2013, Marshall County Ethics Ordinance, termination record for Goldenrod Kirk, notices from Kentucky Unemployment Office, letter from Judge Miller to Kentucky Employment Office, statement by Commissioner Drew, chronology of events by Commissioner Drew, electronic mail messages between members of the fiscal court. We believe we obtained sufficient information to support the conclusions reached. The unemployment issue. Mr. Kirk served as Marshall County Dog Warden or Animal Control Officer for over 30 years. He is now in his late 80s. He served in a part-time capacity for $2,000 a month. In early 2013, some commissioners began receiving complaints from other county employees that Mr. Kirk was no longer able to carry out his job duties. He was unable to drive an automobile safely or to catch stray animals without assistance. One assistant animal control officer, Dennis Tynes, quit because he believed it was unfair for him to be required to perform Mr. Kirk's duties while receiving $1,000 a month. In early 2013, the fiscal court discussed the matter in executive session. All members of the court valued Mr. Kirk's long years of service and not wished to terminate him without exploring other options. It was clear the county would have to hire additional employees to carry out the job duties, and the number of new employees would depend on whether Mr. Kirk continued to work and in what capacity. The court asked Judge Miller to suggest to Mr. Kirk a new job description. He would supervise other animal control officers at a 50% pay cut. Judge Miller was to report Mr. Kirk's decision back to the court. Judge Miller met with Mr. Kirk to explain the new position that the court was offering him. Mr. Kirk did not wish to take the reduced duties or cut in pay. Instead, he inquired whether he could collect unemployment if he was terminated. Judge Miller was uncertain because Mr. Kirk had been a part-time employee. Judge Miller asked Emily Martin, the county treasurer, to call the Kentucky Office of Unemployment Insurance for advice. She did so, and she told the advisor the employee in question had worked part-time. She did not say anything about the reason for the termination. The advisor told Ms. Martin that the employee would be permitted to file for unemployment regardless of his part-time status. He did not offer any advice about whether an employee's reason for termination would qualify him to collect unemployment benefits. Under Kentucky law, an employee may generally collect unemployment if he is discharged by his employer unless the reason for discharge is misconduct. An employee who quits his job is not entitled to collect unemployment, KRS 341-370. An employee who voluntarily terminates his employment for good cause will not be disqualified from unemployment. Good cause exists only when the employee is faced with circumstances so compelling as to leave no reasonable alternative but loss of employment. If an employee's job functions change, he is required to make reasonable efforts to adjust to the work change. Kentucky Unemployment Insurance Commission versus Day. Some substantial changes in terms and conditions of employment that would allow voluntary termination for good cause include significant increase in work hours, substantial new responsibilities, substandard working conditions, and significant work wage reductions. However, Kentucky has not adopted a substantial reduction in salary rule as a good cause for voluntarily terminating unemployment. Raines versus Kentucky Unemployment Insurance. In some instances, an employee may be constructively discharged if the conditions created by the employer's actions are so intolerable that a reasonable person would feel compelled to resign. Brooks versus Lexington-Fayette Urban County Housing Authority. Judge Miller stated that he told Mr. Kirk that he could file for unemployment, but he did not know what ruling the unemployment office would make. Since Mr. Kirk did not submit to an interview, we cannot verify that statement. It was understood by both Judge Miller and Mr. Kirk that Mr. Kirk would leave his duties and file for unemployment. After the meeting, Judge Miller instructed Emily Martin to list the reason in the county's records for Mr. Kirk's termination as laid off. That reason was false. A layoff means that the employee has been terminated because there is a lack of work, and the employer no longer needs an employee to fill those duties. In addition, on February 4, 2013, the county held a retirement party for Mr. Kirk. Judge Miller attended and gave Mr. Kirk a gift. An employee who retires is not laid off. An employee who is laid off from work would be entitled to collect unemployment benefits, and Judge Miller knew it. In this way, he caused a false record to be created which would entitle Mr. Kirk to collect unemployment, and he assisted Mr. Kirk in obtaining a benefit to which he was not entitled. KRS 519-060 makes it a Class D felony to knowingly make a false entry into a public record. KRS 522.020 makes it a Class A misdemeanor for a public servant to commit an act related to his office which is unauthorized exercise of his official duties, functions, with the intent to confer a benefit upon another person. We believe Judge Miller violated these provisions. It is important to note that there has been no financial injury to the county from this action. On January 30th, 2013, a citizen brought to Commissioner Drew's attention that Ms. Kirk was planning to collect unemployment benefits. She reported the issue to the Unemployment Commission in March. Later, Mr. Kirk received a letter from the Unemployment Commission inquiring about the benefits. He returned the $3,000 he had received without protest. The county, therefore, has incurred no draw upon its reserve account or other financial injury. The disclosure issue. Fiscal court discussed matters involving Mr. Kirk at a Mr. Kirk at a June 11, 2013 meeting in an executive session, to which the press and public were not permitted to attend. The day after the meeting, however, an article appeared in the Lake News which described the discussion. Upon inquiry, Judge Miller stated that he had been interviewed by Lloyd Ford from the Lake News, and he gave him the information which appeared in the story. Judge Miller explained he did not believe there was anything confidential in the information he divulged, as he had heard the issues discussed at a number of locations around the county. It appears to be the custom and expectation of the fiscal court that executive sessions will remain confidential. Certainly, the purpose of the executive session is to keep certain kinds of discussion confidential and to provide an exception to the open records and open meetings laws. There is, however, no legal requirement to do so. KRS 422.040, misuse of confidential information only applies when the public servant garners some kind of financial gain from his actions. Therefore, although Judge Miller did not provide the information to the media, doing so did not violate the law.
And you have copies of this for,
Yes, I've got
All
several
the meetings.
copies and can make additional ones available.
any other business?
Jeff, you've forwarded this to,
Oh, yes, when as I said earlier, when when this all came about, I made the Attorney General's office aware of the allegations, and when I received these, this last week, I have now forwarded that to the contact person from the Attorney General's office.
Any other questions? Entertain a motion.
Motion to adjourn.
Motion second? Second. Motion second, all in favor say aye. Aye. Meeting's adjourned.